essence of his endeavor to give the best knowledge and inputs, the Bar Council Maharashtra and Goa today has organized lecture on the topic offences relating to property under the Indian Penal Code. Our resource person for today, Advocate Teajs Dande, I welcome you, sir. On behalf of Bar Council of Maharashtra and Goa, I feel extremely happy to have been given opportunity to give a brief introduction of our today's speaker. Advocate Teajs Dande has graduated in first class from ILS College Pune in year 1997 with first in University of Pune and subject law of torts. Dande sir has thereafter completed his LLM from Mumbai University in subject constitutional law. His specialization involved a deep comparative study of five major constitutions of the world, that is UK, USA, Canada, Australia, and India. Advocate Dande started law practice with Chamber of Senior Advocate Nitin Pradhan in the year 1998 at Bombay High Court. He has appeared in major criminal trials before Sessions Court as well as Honorable High Court. To mention some, one being JJ shootout case and Kalpade murder case. Advocate Dande has also appeared in various PIL before Honorable High Court in public importance issues like Right to Information Act, toll collection at Ahmednagar Highway, noise pollution, environmental law, food adulteration, etc. He has also appeared in a public interest litigation raising the issue of tree cutting during last Kumbh Mela at Nasik, and his efforts saved cutting of almost 3,200 trees for road widening around Nasik. Besides this, Sir also appears in criminal civil arbitration matters in the Honorable Bombay High Court. I invite and welcome you, sir, to share your inputs on the subject offences relating to property. We are surely going to be benefited by today's lecture. Welcome you, sir. Over to you, sir.
Thank you, Shabnam, madam. Respected Gajanan Chauhan, sir, Chairman of the Bar Council of Maharashtra and Goa. Advocate Jayant Jaibhave, sir, Chairman of CLEP Committee. Dr. Rajendra Anbhule, sir, Chief Coordinator of this lecture series. My friend Shri Ganesh Pawar, and also all the participants of today's dialogue and lecture. I am really thankful to Bar Council of Maharashtra and Goa for this opportunity. In fact, I feel it is a privilege for me to be present amongst you all who are going to be future of our Indian judiciary, subordinate judiciary. I'm so happy that such a large number of students are willing to join judicial service. Friends, I must tell you that this judicial service is probably the best opportunity for you all to serve the nation and to serve the judiciary. You all are aware that how the pendency is piling up day by day, how new challenges are coming in our way. The lockdown, COVID situation, unnecessary pendency of the matters, repeated adjournments. So in such difficult times, you all are choosing judicial service is really commendable. What I personally feel is this judicial service is the only service available probably in India where you get both the things. You get opportunity to serve the nation, and also you get opportunity to ensure that you yourself progress in life, your career gets better in life, monetarily, and also otherwise you get enriched by this judicial service. Your knowledge gets used for benefit of the society. Students, I know you are practicing advocates, you have some experience, better experience in law practice, and therefore now, after clearing the preliminary examination, now you are going for main examination of MPSC Judicial Service. I presume that once you have cleared preliminary examination of MPSC, I must tell you that you hold merits in you. I must tell you that because you could clear the preliminary examination, you can boldly and confidently say that yes, you can face the main examination of MPSC. Dear friends, I feel that while preparing for this particular topic, that offenses in respect of property mentioned in IPC, instead of going through the entire philosophy of law, criminology, or the philosophy in respect of criminal jurisprudence, today we are concerned with only question and answers, whatever MPSC going to put in our way. I feel the student who is having ample knowledge about criminology and the law may not be able to crack the exam unless he know the skill of cracking the exam. So you all have to focus only on the skill. You have to learn that how and in which manner I will write the answers for my examiner. Friends, please understand that now onwards, it is hardly, I think, 3 weeks in your hands, exactly 21 days. And after that, you are going to face the big day of your life. I must tell you that these 21 days are going to be very crucial in your life. The way we heard that dialogue in Chak De India, that wo 70 minute. So please understand that these 21 days are going to be extremely crucial. Give your best, give your complete time for this preparation. And I'm telling you, you will never look back in your life. Friends, if you peruse the last few years question paper, say from 2011 or so, I could find that only 6 to 7 topics are there which are being repeatedly put in question paper by MPSC. So we have to play very smart. We have to go very technically. We have to see that on which subjects we have to prepare. Because going by all the sections one by one will not help you in the examination. You have to just expect that these 6-7 topics which are being repeated every time, we have to focus on those topics only. What I have observed is that the topic of theft and extortion, robbery and dacoity, thereafter criminal trespass, lurking house trespass, housebreaking, and thereafter dishonest misappropriation of property, criminal breach of trust. These are the questions which are being repeated every year in the examination. You may also note that one more subject, that is forgery and making of a false document, that has also come twice in last 10 years. But most importantly, the topic of theft, extortion, robbery and dacoity, this is being repeatedly put to students. Now, if you see the nature of question paper, many a times only short note or a short answer is expected on these particular subjects. On 2-3 occasions, the judgment writing is also covering this topic of offenses against property. So if the judgment writing topic comes with offenses against property, then you will have to be ready for any topic from this particular chapter 17 and 18. Friends, I must tell you that before starting our discussion, everyone must have bare act of IPC with him or her, so that you will be able to read and understand what I'm trying to tell you. In today's dialogue, I may require to read certain portion from the provisions itself, but please understand that there is no other option than to go through the exact wordings employed in the statute, that is IPC. So therefore, we must refer to the bare act time and again. Some people may think, then what is the great deal? What is the big issue in reading out the provisions? But friends, I'm going to read the provisions in such manner which would make you understand the meaning of particular word, which would help you to digest the concept of particular provision. And therefore, I'm requesting all of you to have your bare act with you while going ahead with this particular dialogue. I must also request all of you that while preparing for this particular topic, you should also read the basic things in IPC and CRPC, that is the definition part. You are well aware that the definitions are specified in IPC and which are very important for our purpose, like what is electronic record, what is valuable security, what is document, and thereafter the important things like what is injury, what is life, what is death, what is the meaning of oath and section and all that. You will have to also see the provisions in respect of territorial jurisdiction. You will also have to see the provisions in respect of limitation, that during what period of time you can take cognizance of particular offense and all that. So these are the basic things which you should keep in mind. You should read once before going to your examination. Friends, also I'm willing to tell you that while appreciating the provisions of law, you have to just focus on the concept of particular offense. It is not expected from the examiner that you write each and every word from the provision as it is, and it is not expected that you reproduce the provision and section as it is. Please understand that your knowledge of concept, whether you have understood the concept properly, whether you have understood that what amounts to this particular offense, what makes this particular thing as an offense, what are the ingredients of this particular offense, those are going to be examined by the examiner. So students who are having a feeling that I'm not aware about any amendments recently happened to the IPC, I'm not aware about any recent case laws in this particular of section and all that. So absolutely don't worry on that. This is not the exam to check your refreshed knowledge, or this is not the exam to check whether you are updated about the case laws and all that. What is expected at this point of time from MPSC main exam is whether you are aware about the basic concept of law. whether you are able to differentiate between the two offenses which are having a very thin line of differentiation, like theft and extortion, robbery and dacoity. Are you in position to make out the difference between these two by going to the ingredients of that particular provision? So this is what expected. So please have confidence that you have to focus on the provisions, and don't think that you have to read the updated case law, you have to go to the software, you have to see the what is the recent case law, what is Bombay High Court is saying, what Supreme Court is saying. Yes, I can understand that a basic knowledge about the updated case law you may have, or you may keep yourself updated on that, but don't discourage yourself or don't get disappointed that if you are not having these information ready with you. So now coming to the basic provisions of IPC, you are well aware that we are going to start from section 378 of IPC, that is theft. So how it is defined and described in IPC, that you will have to see. Please read the provisions very slowly, because reading the provisions slowly would give you perhaps the actual meaning hidden in that particular provision. Therefore, I am requesting you all that though you find it monotonous, though you find it that we can read on our own, though you feel that I have my book at my home, I don't need to spend my time with this lecture, but I'll request you that as a law practitioner, probably you may get some different perspective while I read the particular provision. Friends, you are aware that 378 says that whosoever intending to take dishonestly any movable property out of the possession of any person without that person's consent moves that property in order to such taking is said to commit theft. Now going to the ingredients of this particular section, there are 5 ingredients which are very crucial. So whenever such question comes, it is your duty to remember that if theft comes, I have to write 5 ingredients in any case. So which are those 5 ingredients? The first is dishonest intention. So consider a situation that few colleagues are sitting across the table. Your pen and your colleague's pen is identical, same color, same make, same look, and your pen is already there in your bag, but inadvertently you feel that the pen which is there on the desk of your friend or your colleague is your pen, and you take that pen from him and keep it in your pocket. Later on, next day, you realize that my pen is already there in my bag and I took his pen from the desk. So would that amount to a theft? Friends, please understand that dishonest intention matters a lot. I should have a dishonest intention that my friend is having something different pen and I should take that pen from him without his consent and I should remove it from his possession. But there is no dishonest intention while taking his pen, which is very identical to your pen. So here the dishonest intention is missing in the entire act. If that is so, the theft will not make out. So therefore, the first intention when the theft question comes, whether dishonest intention is there or no. Thereafter, whether the property is movable or not. So please understand that the theft occurs only in respect of movable property. Now, what comes under movable property, that also you have to note. Few times it happens in our rural places or villages that there is a sandalwood tree. So this sandalwood tree is fixed on the land. If it is fixed, it is not a article, it is not to be taken away, it cannot be removed from possession of anyone. So therefore it will not be a subject matter of theft. But if you cut that sandalwood tree, then it becomes a subject matter of theft. So please understand what I'm trying to tell you is that the subject matter should be movable thing. Same thing applies to your cattle also, your dog also. So it is a movable thing and movable property, and therefore it is subject matter of a theft. Thereafter, the third ingredient is without consent. So please understand that suppose a cow is there, it is tied by the farmer to his particular place, but you remove that tie or that rope without the consent of that particular farmer, and you invite that cow to follow you. In such situation also, this is without taking any consent of the owner, and therefore amounts to theft. And similarly, the next two ingredients are out of the possession of another and removal of property. So the property should be taken out of the possession of a person. The offense of the theft is an offense against possession and not against title. This aspect also you should know, that whether it is your ownership or no, it is not concerned with the theft. Theft is only looking towards the possession. You have that particular pen in your possession is what matters for theft. But whether you are owner of that particular pen is not material for considering the theft aspect. So therefore, possession of a particular thing, article with you, and taking away, removing that possession without your consent with dishonest intention is what amounts to theft. Now, with these ingredients of theft, I will request you to read all the illustrations and also the explanations given in the provision. The illustrations and explanations, these are given in the IPC just to clarify your concept, just to make the things simplified. Don't get confused by reading those explanations or by reading those illustrations. Therefore, one by one, if you read the explanations, you will understand that the concept of theft lies within the four corners of these 5 ingredients, which I have just now narrated to you. I will again repeat all those 5 ingredients because the object of today's lecture, what I feel is that you should clarify your concept clearly. So on the day of examination, you need not read theft provision again on that day morning. You just remember 5 ingredients of theft. And what is that? Dishonest intention. It should be a movable property. It should be without the consent. It should be out of the possession of another, and removal of the property. This is one. Now, after 378, the aggravated forms and punishment, all that has been prescribed in IPC. I will not take you to those. I will directly now invite you to the next concept, and that is extortion. Now, friends, please see. This extortion is defined as whoever intentionally put any person in fear of any injury to that person or to any other, and thereby dishonestly induces the person to put in fear to deliver to any person any property or valuable security or anything signed or sealed which may be converted into a valuable security, commits extortion. So basically the concept is that by giving threat or by putting someone in the fear of injury, if you are making that person to work as desired by you, that would amount to extortion. Now, just note the ingredients of extortion. To invoke section 383, the first ingredient is the person must intentionally, please note the word intentionally, put any person in fear of injury. Second, such fear of injury is to that person or any other. So that means, take an example that X goes to his business partner and then he says that I will kill you, or I will kill your daughter who is in my custody. So if you are putting him under the fear of injury, and for what? That if you don't do this particular thing, then in that case you will be put under the fear of injury. I will repeat that ingredients of extortion says that a person must intentionally put any person in fear of injury. The second ingredient is such fear of injury is to that person or any other person. And the third, such injury should be to induce the person so put in fear to deliver to any person any property, valuable security, or anything signed or sealed which can be converted into a valuable security. Friends, in the beginning itself, I mentioned to you that you have to keep referring to the definitions given in IPC. Now, what is valuable security? You have to immediately check to the definition of valuable security given in IPC. Now, the situation is such that two business partners, one business partner wants to get some advantage from his other partner, and for doing that he is putting that other partner in the fear of injury. So now that fear of injury would be directly to him or to some other person. Like I told you that if the partner threatens the other one that I will kill you if you don't sign this document, or I will kill your daughter if you don't sign this particular document, that is the fear of injury you created. And thereafter what you got? You got a particular valuable security in your favor. So this pressure, threat, coercion on the particular partner, this particular event makes extortion. So friends, you have to understand these illustrations of extortion. And now, please note that a very common question is put in the examination, that what are the differences between theft and extortion? So you have to also be prepared for this question. You have to be very clear on this particular aspect. I have clarified the theft aspect. I have clarified the extortion aspect. The added part in extortion is that you put somebody in fear of injury for himself or to other person, and then you make him sign or transfer that valuable security which you are otherwise not entitled to from him. So this is what the extortion part is. Now let us see the exact difference between theft and extortion. You please make note of this, because this is a very important question, though it is coming for hardly 5 marks. Friends, you are aware that on 29th August lecture, Shri Avhad sir has specified you that even 1 mark matters a lot in judicial examination, because the once cutoff is declared, so that cutoff mark would be same to n number of students. Therefore, even half mark, even 1 mark matters a lot to you. Therefore, even if this particular topic is covering hardly 5 to 10 marks in the entire question papers, you have to be very mindful that if you have to crack this examination, these 5 marks are going to matter a lot. So coming back to the topic, this is a difference between theft and extortion. So the dishonest intention to obtain property is common to both these offenses. Dishonest intention is common in both these offenses, but extortion may be thus distinguished from the theft, as extortion differs from theft by obvious circumstances, that in extortion the consent is obtained by putting the person who is in possession of the property in fear of injury to him or to any other. Extortion is thus committed by the wrongful obtaining of consent. And in theft, the offender's intention is always to take without the owner's consent. So please understand, in theft, a thief would feel that I will go to this particular place, I will take the jewelry, and I will come out without making myself known to anyone. So this is what theft, a normal concept in a common man's conception. And what is extortion? In extortion, this offender goes face to that particular victim. He puts him in some fear. He puts him in fear of injury, and then makes him give something which he is otherwise not entitled. So this is the basic difference between extortion. In extortion, you put that other person in fear of injury. Now the second difference is, the property obtained by extortion is not limited, as in theft, to movable property only. Now please remember, the second ingredient which I narrated you for theft is it should be a movable property. Here in extortion, it is not limited to only movable property. It can be a valuable security. It can be an immovable property. It can be a right to enjoy something. So this goes to some civil contractual rights also. So therefore, this extortion is a very broader concept. Therefore, please understand that the difference between theft and extortion, this extortion is not limited to only movable property. Now, immovable property may be the subject matter of extortion, whereas immovable property cannot be the subject matter of theft. Now, I'll turn to third difference between theft and extortion. In theft, the thief takes the property without the owner's consent. In extortion, the person intimidated is induced to deliver the property. So therefore, the other partner, which I just now gave the example, has signed a particular document or has given a particular valuable security to this other partner consently, but that consent was given under fear of some injury. So therefore, the element of delivery does not exist in theft as in extortion. And now the fourth difference between these two would be that the extortion is committed by overpowering the will of the owner and thereby dishonestly inducing him to deliver his own property. In theft, the element of force or fear does not arise. So friends, please note that this is a very important question which you are going to probably face in your MPSC examination. So theft, concept, ingredients, please note. Extortion, I have explained you all the ingredients and also explained the differences between theft and extortion. Students, I am aware that we have very limited time, but I have decided that I will probably go with this slow pace only. So whatever we cover, you should have a clarity in mind about these concepts. And therefore, whatever subjects we can cover during today's lecture, I will try that you understand the concept clearly so that on the day of examination, you need not read the book again. So now let us coming to the next section, and that is of robbery. So now all this is one family: theft, extortion, robbery, dacoity, but there is a little difference between these two. So what that differentiation part that you have to keep in mind. So basically the main concept of theft you realized, extortion you realized. Now come to robbery. Robbery, it is a serious and aggravated form of theft and extortion. Please understand that in all robbery cases, it is either a theft or extortion. So now the basic concept is clear. So in robbery, it would be either theft or extortion, nothing beyond that. Now, when it is robbery, when theft is a robbery, that you have to see, and when extortion is robbery, that you have to see. Please understand that IPC also specifies this robbery in this manner only. So you have to keep in mind that robbery is either theft or extortion, but what is that you have to find out from the provision. Now please come to when theft is robbery. Theft is a robbery if in order to committing of the theft, or in committing the theft, or in carrying away or attempting to carry away property obtained by the theft, the offender for that end voluntarily causes or attempts to cause to any person death or hurt or wrongful restraint or fear of instant death or of instant hurt or of instant wrongful restraint. So now again go to theft. Only addition is that while committing a theft, this particular offender causes some hurt, some wrongful restraint or death to the victim, and then it is a robbery. So this is aggravated form of robbery. Suppose you take an example of a village, a small village or a small town. There these 4-5 these particular group, or say 1 or 2 persons, they were keeping watch on a particular house, and they observed that since last 4-5 days this light in this particular house is not getting lit. That means this person is gone out of station, and so this is the best place to conduct stealing. This is the best place to go for theft. This is what their planning is. Their intention is to take away jewelry from that particular home. But then a thief says that probably someone would be there. If he comes, I should clear him from my way. So he carries sickle along with him, or he carries some stick along with him. And then he enters this particular house. But unfortunately, on the same day, the owner of the house is returned back from out of station and he is there in the house. So when the thief realizes that this particular owner is already there in the house, then what the thief does, he locks his particular room and then he goes to the other room to steal the things. So in this particular incident, what the thief does, he enters with some weapon. He realizes that the owner of the house is still there. So therefore he locks him in a particular room and then carries out his act of stealing in the other room. So friends, please understand, because to remember all these aspects, you have to imagine or visualize such type of incidents. This will give a clear picture before you that how robbery is conducted, how robbery is carried out. So therefore, this particular person uses force, uses a weapon, uses something which has caused that other person hurt, or which has prompted that thief to wrongfully restrain a particular person and then carry out this particular theft, then it is robbery. Now come to extortion part. Extortion is a robbery if the offender at the time of committing the extortion is in the presence of the person put in fear and commits the extortion by putting that person in fear of instant death, instant hurt, or instant wrongful restraint to that person or to some other person, and by so putting in fear induces the person to put in fear, then and there to deliver up the thing extorted. Now you have to visualize an incident that these two partners, so now this partner comes along with a gun in his hand and he puts that gun in front of the other partner and says that if you don't sign this particular document, I will kill you here and here itself. So this particular threat given by one partner to other partner to extract or to get that consent which he is otherwise not entitled to, and by exerting this particular way of threat or the fear of hurt or death, you are obtaining the valuable security from the other partner, and therefore then this amounts to robbery again. So theft, extortion done with the threat of hurt, wrongful restraint, or death would amount to robbery. Very clear. And note the ingredients also, that a theft is robbery if the offender voluntarily causes or attempts to cause to any person death, hurt, or wrongful restraint, then that theft is robbery. Fear of instant death or instant hurt or instant wrongful restraint is also robbery. Then this act must be done in order to the commission of the theft, or in committing the theft, or in carrying away or attempting to carry away any property obtained by theft. Similarly, the ingredients of extortion amounting to robbery. So whenever extortion is conducted by the offender by putting that person in fear of instant death, hurt, or wrongful restraint for taking that benefit which I have already described, this amount to robbery. Friends, the concept is very simple, that anything in aggravated form, anything which is under the threat of death, wrongful restraint, or hurt, and connected to theft and extortion would amount to robbery. Now come to next provision, and that is of, say, dacoity. So the difference between dacoity and robbery is only one, and that is in dacoity, the number of persons is different. There is actually no difference between robbery and dacoity except in the number of offender. Robbery is a dacoity if the person committing robbery are 5 or more in number. The dacoity is also termed as gang robbery. The offense of dacoity consists in the cooperation of 5 or more persons to commit or attempt to commit robbery. It is necessary that all the persons should share the common intention of committing robbery. Now let us take example of robbery. That this gang of 4 or 5 people, they decides that today night I am going to visit this particular place and I am going to steal away the jewelry from that particular home. Now one person says that probably there is lot of jewelry which I cannot carry in my pocket or in my shoulder. So I will require one porter, or I will require someone who will help me to carry out that or to take away that particular jewelry or valuable items from that particular home. So he was looking for someone who will help him to just take away that particular stolen items out of that particular place. The other person says that that is all right, but we will require one vehicle also to visit there and to get away from that particular spot immediately. So now he says, okay, all right, you hire one vehicle or you hire some taxi from somewhere else. So that driver comes with taxi. This porter comes only to carry something. These two persons, the porter and the driver of vehicle, are absolutely having no knowledge that what these people are going to do. They says that if I am getting my 500 rupees for carrying away or some lifting of articles, items, I am happy. Driver says that if I am paid for 1 day of driving, I am happy. So I'll come with you. It is my job. I will come with you. The reason I'm giving you this example is that 5 people are going for robbery. 5 people are going for this particular illegal act. But the other 2 people, that porter and driver, they are not having any idea. So they are not having any common intention of committing the robbery. So you can't convict these 2 persons for robbery. Please understand. So the reason I'm telling you this again and again, that in robbery, common intention is very crucial. So this driver cannot be convicted for robbery purpose. This porter cannot be convicted for robbery purpose. So now, after noting this common intention aspect, you please note down the ingredients of dacoity. The accused commit or attempt to commit robbery. The person committing or attempting to commit robbery and the person present and aiding must not be less than 5. And all these persons should act conjointly. So sometimes it happens that only 3 persons commit this particular act, and these 2 persons, which I told you, driver and the porter, they are not having any common intention, no knowledge about the particular theft or extortion or robbery, anything. So can you convict these people for robbery? This type of question would come in probably judgment part, that if the facts are given like this, then what do you supposed to do? So while giving the reasoning part, while assessing or while examining the evidence part, you have to keep it in mind that if the question of robbery comes, the common intention of all 5 has to be established very categorically. Now coming ahead of these aspects, now let us go to dishonest misappropriation of property. That is section 403. Friends, if I'll just go back to these three aspects: theft, extortion, robbery, dacoity. If you complete these four things very clearly, I feel that you would be certainly able to answer at least two questions on this part in the question papers. So be prepared for these four things very clearly. Now, coming to criminal misappropriation of property, this question has come only twice in last 10 years. No, only once. In 2012, dishonest misappropriation of property and criminal breach of trust. So this question was put for 2.5 marks. Dishonest misappropriation of property, only 2.5 marks. But as we discussed, every half mark is important. So please see that what is dishonest misappropriation of property. Section 403, whoever dishonestly misappropriates or converts to his own use any movable property shall be punished with imprisonment of either description of a term which may extend to 2 years or with fine or with both. Now, I will read one illustration for this. A and B, being joint owners of a horse, A takes the horse out of B's possession, intending to use it. Here, as A has a right to use the horse, A does not dishonestly misappropriate it. But if A sells the horse and appropriates the whole proceeds, but if A sells the horse and appropriates the whole proceeds to his own use, he is guilty of an offense under this section. In simple language, two friends decides that we go to school and tuitions together. Let us buy a bicycle jointly in partnership. We will attend our college, school and everything on this particular bicycle. This bicycle was purchased with 50% payment, but one friend takes that bicycle for his personal use 2-3 days, 4-5 days, and again returns back the particular bicycle to the friend. There is no offense. But the friend takes away this particular bicycle, sells it in the market and appropriates the sale proceeds alone, then it amounts to the offense. It is that simple. Just remember these ingredients and explain the concept clearly while writing the answer. Friends, just pausing here for a minute, pausing from the provisions of law, I will request everyone to also keep it in mind that while writing an answer to particular question, you should adopt a very smart way of writing the answer. I will suggest that while starting any answer, you should give a very brief idea about what you are going to cover in your answer, whether it is a short note, long note, or whatever would be the essay or whatever. Awad sir has given you a detailed information on 29th August lecture. Please hear it again and again before appearing for the exam. But also learn to write answer very smartly. To begin with, you have to write what is the scope, what is the nature, what are the ingredients, what are the case laws you are covering, and what are the final outcome of this particular short note or a long note or an essay you are writing. Because the examiner should get the idea of your answer immediately when he sees the first 4 lines of your answer. He should realize that you have covered the section number, you have covered the ingredients of that particular answer and everything. Because you are also have to keep the time management in your account. You have to manage the time very smartly. So therefore, even if your answer gets very small, doesn't matter. But in introductory part, you have to write the exact gist of your answer. I'm again repeating that examiner should get overall idea that what you are going to cover in your answer. So adopt and follow this smart way of answering a particular question. This will help you to score high marks. Now coming back to our topic again. Now let us see what is criminal breach of trust. We are having very less time in our hand, but we'll try to cover as much as possible. See, criminal breach of trust is mentioned in section 405 of Indian Penal Code. It defines criminal breach of trust, and section 406 prescribed punishment. And the basic ingredient of this particular section is entrustment with the property or with dominion or power over a particular property, and dishonesty, misappropriation with dishonest intention. These are the ingredients which have to be kept in mind. To invoke section 405, a person is in any manner entrusted with a property or dominion over property, and he dishonestly misappropriates or converts to his own use that property, or dishonestly uses or disposes of that property in violation of any direction of law prescribed the mode in which such property should have been discharged or disposed of. I will give a simple example to understand the thing. Suppose there is one trust, and the trust declares that we will give scholarship to the deserving people, economical weaker section of the society, to students whose income is having 5,000 annually. This is what their law prescribes. A trust, the trust declares particular the scheme. Now the trustee or the manager, he feels that this charitable trust is giving money in scholarship to the students. Why don't I appropriate this money in some manner? So now what he does, he opens a fake account on some name, and he shows that this particular named person is given scholarship, but that money comes to his fake account and that money is appropriated by him. So in this entire transaction, entrustment with that trustee or that manager, and there is a law, there is a prescription by the trust that we are supposed to give this scholarship to this particular economical weaker section students, but this particular manager or the trustee dishonestly creates some scene, creates some fake account, transfer this particular money, disposes of this particular money on the pretext that he is giving scholarship to that particular student. He appropriates this particular amount to his own use, and this amounts to criminal breach of trust. So these are the ingredients of criminal breach of trust which you should keep in mind. I will give another example. Say suppose a broker is there who invests money of his master in stock exchange. His master entrusts a chunk of fund money to this particular manager, broker, saying that you please invest this money in Tata Capital or some Reliance Energy fund and etc. But this particular broker feels that no, today the share rate of this particular share is very high. It would not be beneficial to my master in future. So instead of Reliance Energy, I will invest this particular fund in some blue chip fund, some other blue chip fund. He invests that. But then will that amount to criminal breach of trust? the section says no because there was no dishonesty. The reason to give such example is that the dishonesty is the crucial aspect of criminal breach of trust. Please understand this example. In the first example, which I gave to a trustee and a manager, their dishonesty was the basic element in the entire transaction. Here in this particular transaction, the broker invests the money of master, but with a bona fide belief that this money would grow better in this particular fund, and therefore I am investing in it some different fund. That doesn't make him guilty of criminal breach of trust because there was no dishonesty. Now moving ahead to the next provision, and that is criminal trespass. Friends, I have only 15 minutes in my hand. This criminal trespass, lurking trespass, housebreaking, this question is also getting repeated in question papers very frequently. I must tell you, the question of what is criminal trespass, what is lurking house trespass, housebreaking is repeated for 4 years in last 10 years. Sorry, 4 times in last 10 years. Even there was one judgment writing topic on this particular house trespass issue in 2012. 2008, 2011, 2014, all the 3 years, this question is repeated. So therefore, I am requesting all of you that after knowing the basic ingredients of criminal trespass, you should focus on these provisions, this question very meticulously. So now let us go to criminal trespass aspect. Section 441. Whoever enters into upon a property in possession of another with intent, I am repeating the word and pressing the word, with intent to commit an offense or to intimidate, insult, or annoy any person in possession of such property, or having lawfully entered into or upon such property unlawfully remains there with intent thereby to intimidate, insult, or annoy any such person, or with intent to commit an offense, is said to commit criminal trespass. So be clear on criminal trespass aspect. Here, the offender is entering into somebody else's premises, but that entry would be, firstly, should be illegal. You are not supposed to enter his premises. Despite of that, you are entering. The second aspect of entry is you enter legally, but be there illegally. That is also criminal trespass. So the ingredients include a person enters into or upon property in the possession of another. The property should be in possession of another. Second, the person having lawfully entered upon such property unlawfully remains there. Third, he does so with intent to commit an offense, thereby to intimidate, insult, or annoy such person. Now let us take a very simple and basic example. In cities like Mumbai, Pune, or for that matter even in a town, a salesman rings the bell of door. The lady opens the door a very little and asks, yes, who is that, whom you want to meet? The salesman says, ma'am, I am having this product, I want to sell it, this, that. The lady says, no, I don't want this. She tries to close the door. But then the salesman forcefully enters, pushes the door and enters that particular home with an intent to commit some offense, because that particular salesman, he pretends as if he is a salesman, but he is having a malafide intention to commit some offense, either to rob or to theft or something like that. So that forceful entry in the house is a criminal trespass. Take this story a little differently. The lady allows that salesman. She says, okay, show me what products you are having. He enters legally into that particular home, and then he refuses to go out with some intent, either to commit offense or to annoy her or to intimidate her or something like that. Then also it is a criminal trespass. So these are ingredients of criminal trespass. Please remember that I am just giving a basic examples of these things in our common language or from our regular life. Unless you visualize these things by way of such type of examples, you will not be able to recollect these ingredients at the time of writing your answers. And therefore I am trying to give such basic examples. Don't apply your legal and technical mind to these examples now, that how, why would he enter like this and that. So just I'm trying to tell you that someone is trying to enter the house either forcefully, trespass, enters legally but remains in the property, criminal trespass. Now coming to the lurking house trespass, it is section 443. The ingredients are: the person commits house trespass. He does so having taken precaution to conceal such house trespass from some person. So secretly he is trying to do that. It is a lurking house trespass. That person has a right to exclude or eject the trespasser from the building, tent or vessel which is subject of the trespass. Now going ahead with house breaking, that is section 445. This house breaking section is a little lengthy and longer section, but you have to read it calmly, and it is very simple thing to say that someone is entering the house by some illegal way, not from the door itself, not from the door which is meant to enter. That is the crux of this particular section. So I will read that house breaking is: a person is said to commit house breaking who commits house trespass if he effects his entrance into the house or any part of it in any of the 6 ways hereinafter described, or if being in the house or any part of it for the purpose of committing an offense or having committed an offense therein, he quits the house or any part of it in any of such 6 ways. That is to say, now what are the 6 ways which are prescribed under IPC? Please note. The first is that he himself makes a passage, or someone who is aiding him makes a passage. Like suppose this particular thief want to enter a property, but he is avoiding the main entrance door, he is avoiding the window also, but he is creating his own some secret, some new entrance or passage to this particular property. House breaking. Number 2, obtains access by scaling or climbing over any wall or building. So you understood, visualize some scene from a movie that a thief is climbing on particular building with the help of rope, and in that manner he enters a particular premises. House breaking. Thirdly, the passage was not intended by the occupier of the house to be opened. Suppose a particular door which is kept locked forever by the owner, and that particular door, suppose a back door of particular premises, particular property, is opened by this particular thief, and that is house breaking. Now fourthly, if he enters by opening any lock in order to committing the house trespass. So a simple thing that he, by using some trick, opens the lock, house breaking. Now, when I'm saying enters, it also includes getting out. Exit, it also means that. And either enter or exit, any one of it would amount to housebreaking. Now, fifthly, by using criminal force or committing an assault or by threatening any person with assault. So someone goes with a lathi or a stick or a sickle, he attacks on the watchman and enters the premises, housebreaking. Now, sixthly, which this enters by a passage which he knows to have been fastened against such entrance or departure and to have been unfastened by himself or by an abater of the house trespass. So some door which was deliberately and purposefully closed down by the owner of this particular premises, and if that door is opened to enter the particular property, that will also amount to housebreaking. Friends, so in these 6 eventualities, housebreaking occurs under section 445 of IPC. Ingredients I have explained to you. Now, I will request you to appreciate forgery aspect, because the question of forgery is repeated in 2012, thereafter 2017, and probably in 2021, considering the year chronology. So please give your focus on forgery and making of false document. So forgery, section 463, whoever makes any false document or false electronic record. Now the word electronic record has come. You have to refer to section 29A of IPC definition, which says what is electronic record, what is document. So please refer to those definitions, and while writing your answers, you are expected to mention these sections in your answer, that electronic record is defined in so and so section of IPC or the document. So this will enhance the beauty of your answer. Please try to understand, friends. I am trying to tell you that toying with various sections from various acts gives a clear picture that you are having a deep knowledge of the topic. Therefore, now coming to forgery, whoever makes any false document or false electronic record or part of document or electronic record with intent to cause damage or injury to the public or any person, to support any claim or title, or to cause any person to part with property, or to enter into any express or implied contract, or with intent to commit fraud, or that fraud may be committed, commits forgery. So now going by one ingredients, a person makes any false document or part of document, and his intention is to cause damage or injury to the public or to any person. Why? To support any claim or title, to cause any person to part with property, to enter into any express or implied contract, to commit any fraud, or fraud may be committed. So this is forgery. Please understand that someone using a check leaf, suppose a check is given by my boss to me, and I realize that the amount mentioned in the check is 100 rupees. The words are not written by my boss. He has mentioned that you please put the words on your own for that particular figure. So what I does, I just put 2 more zeros. So 100, I make it 10,000. And then in words, I write 10,000 and put it for clearing, forgery. So the ingredients, you please see: causing damage or injury to some person or public. Why? To support any claim, to cause any person to part with the property, to enter into any express or implied contract, to commit any fraud, or that fraud may be committed. So this type of action on the part of offender would amount to forgery. Now coming to making a false document. I'm sorry, I'm running out of the time, but organizers may forgive me for 5-10 minutes. I will be able to conclude in 10 minutes only. So now, making a false document. A person is said to make a false document or a false electronic record first, who dishonestly or fraudulently makes, signs, seals, or executes a document or part of document, who makes or transmit any electronic record or part of any electric record, affixes digital signature or any electronic record, makes any mark denoting the execution of a document or the authenticity of a digital signature. See, the only reason I'm reading out this particular provision from IPC is to make you understand that ingredients of making a false document are restricted to 3 cases which are mentioned, that who is making a false document with a particular intention. Now this intention of causing it to be believed that such document was made or signed by a person. I'll read: with the intention of causing it to be believed that such document or part of document, electronic record, or digital signature was made, signed, sealed, executed, transmitted, or affixed by or by the authority of a person by whom or by whose authority he knows that it was not made, signed, sealed, or executed or affixed. That means, in short, it wants to say that something is done to pretend as if it is done by the person who is having lawful authority to do it. This is first eventuality. In short, a manager is pretending that this particular hundi or this particular check is signed by my boss, but it is not signed by him, but he creates this document falsely. This is what the eventuality 1 has mentioned. Now, secondly, who without a lawful authority, dishonestly or fraudulently, by cancellation or otherwise, alters a document, electronic record, in any material part thereof, after it has been made, executed, or affixed with digital signature, either by himself or by any other person, whether such person be living or dead at the time of such alteration. Suppose some power of attorney is executed, it is registered, everything is done, but this offender makes some changes here or there. Somewhere he adds the word not, or somewhere he adds the word also this property, or somewhere he add the word which will damage the particular owner. So this amounts to creating a false document. Now the third eventuality. So this I'm giving example of power of attorney is given because the word used in second eventuality is that when this particular document is already done, prepared, then also you creates it, alters it, modifies it, that amounts to making a false document. So power of attorney registered, executed one document. but you putting some extra word in it, modifying it, amounts to making a false document. And now the third and last eventuality is whoever dishonestly or fraudulently causes any person to sign, seal, or execute or alter a document on a or an electronic record, or to affix his digital signature on any electronic record, knowing that such person by reason of unsoundness mind or intoxication cannot, or that by reason of deception practiced upon him, he does not know the contents of the document or electronic record or the nature of the alteration. So here various aspects are involved. First, you deceive someone, deception. You say, no, this is like that, this is not like that, you please take this something, a different case. You try to convince that particular person that you have to sign this particular document because the situation is not what you are thinking, the situation is this which I am telling you, and therefore you sign this particular document. This is deception. You try to cheat, you try to impress upon him something which is not there, and then you make him sign under that impression. So this particular person who is signing a document is carried away or is influenced by your deception, and then he signs that particular document, then also it amounts to making a false document. Now similar thing happens with a person who is of unsoundness, of mind, or who is under intoxication. So in short, the section tried to say that the author of particular document, if he is not in position to understand the exact nature of that particular offense, of that particular document or that particular thing which he is signing, then though he signs on his own, that amounts to making a false document. So now friends, I think I should stop here because it is already 7:33. So I am just concluding now. I am giving you a list of 6 topics again for those who have joined subsequently, that these 6 topics you must focus on because these questions are getting repeatedly appearing in the question papers. The topics are: first, criminal trespass, lurking house trespass, house breaking, house trespass. Very important question. Please focus on that. Thereafter, theft, extortion, robbery, dacoity, difference between theft and extortion. Very important question. Thrice it was asked. Please focus on these topics. Thereafter, dishonest, misappropriation of property and criminal breach of trust. Also cover cheating. This was asked only once in 2012, but it is always better to prepare this particular topic. And then lastly, forgery and making of the false document. So with this, I conclude today's lecture, and just a passing advice to all my friends that though you are having only 21 days in your hand, you can change everything in these 21 days. Give your best, give your 100% to the studies. Try to appreciate and understand the concept of law. It is not expected that you write word to word in your answers. Secondly, maintain your psyche and also your cool temperament. Focus on your physical health also. Please ensure that you take complete sleep of 7 hours every day, because a peaceful mind would able to take and grasp the concept very clearly and would be able to reproduce what you have read and studied in these days. Please focus on meditation. Also take help of yoga for these few days. because sitting whole day at home will not make you active, will not make your brain active. It is your duty to keep your brain active throughout your 21 days. So please spare a little time for your physical health also. Don't compromise on your hours of sleep. With all these advices, I wish you a very good luck, all the best for your examination. Thank you very much. Mr. Pawar? Yes. Yes.
Thank you so much, sir.
Yes. Your voice.
Patara ma'am, you are not audible. Not audible.
Pathare madam is not audible. I think.
Mm. Yes, Patara ma'am. Thank you so much, sir. On behalf of Bar Council of Maharashtra and Goa, I am very much thankful to you for enlightening all the participants on the most important topic of mains examination, that is offences relating to property under IPC. And also you have covered forgery, which is also important aspect. I am very much thankful to you. It will be helpful to all our participants, even in judgment writing also. Thank you so much. There is one announcement that tomorrow lecture is at 10:30 a.m. Dr. Uday Varunchikar sir will guide us on the topic of prevention of atrocities to SC and ST and protection of civil rights. Thank you so much, Dande sir, and all the participants. Sharat sir, please end the meeting.
Thank you very much.